a few moments. We're still waiting for some attendees to log in. Thank you. Commissioners, you can start your video and audio.
Well, welcome, commissioners. It's good to see all of you again. I heard something.
I said, and you too.
Well, it's very kind of Commissioner Garcetti. Thank you very much. So this is a hearing on the California Environmental Quality Act, Part 3, Thursday, April 27 of 2023. Let me first start by expressing my gratitude to the Commissioners Emerson and Aaroner for the op-ed that they penned with respect to our most recent report on providing assistance to the disabled in California. I think it was particularly poignant, right on, and it got the attention it deserves. And let's hope that it has some ripples across the street over in the Capitol. But Ken, thank you so much for taking the time to present that information. I'm Pedro Nava, and I'm the chair of the Little Hoover Commission, and thank all of you for joining us today. I want to introduce the other commissioners who are here with us on Zoom. We have Vice Chair Sean Varner. Commissioners Dion Aaroner is not here yet, but I expect that she will be joining us. David Byer, Anthony Canella will probably be joining us shortly. Bill Emerson, Gil Garcetti, Jose Atilio Hernandez, and Jana Sidley. There are legislative members, and I'm going to name them because frequently there are staff that attend the meetings, and sometimes the legislators, depending on their calendars, do as well. But members of this commission who are legislators are Philip Chen, Senator Scott Wilk, and Assembly Member Liz Ortega. Also with us are commission staff, Executive Director Ethan Rarick, Deputy Executive Director Tamar Foster, Analysts Ashley Hurley, Ali Powell, and Sharon McAllister, along with project managers Crystal Beckham and Tristan Stein. We got to do a little bit of housekeeping before we turn to the subject at hand. Commissioners, your audio and video will be turned on throughout the duration of the hearing. You may mute yourself if you wish. Please remember to unmute yourself if you want to make a comment or ask a question during the hearing. As is our practice, I'll be looking for upraised hands across the screens when it is that you want to make a comment or ask a question. The video and audio of our hearing witnesses will be turned on when they present. Members of the public will be muted during the hearing. We will have a public comment session at the end. Those who wish to make a comment will be unmuted during that public comment session. If you'd like to make a public comment, please use the raise hand feature in Zoom by clicking on the hand icon to join our public comment queue. Those who have joined us by phone may either dial #9 to raise their hand on Zoom or send an email to our Little Hoover email address, letting us know that you want to speak to the commission. You must provide the phone number from which you have joined the meeting so that our staff knows who to unmute. Staff will be monitoring raised hands and emails requesting comment throughout the duration of the hearing. As is usual, public comment is limited to 3 minutes per speaker. We are recording today's hearing, and after the hearing, staff will place a permanent link to the recording on our website and upload it to our YouTube channel. And now to the substance of today's hearing. This is the third in a series of commission hearings examining the California Environmental Quality Act, or CEQA. Since its creation in 1970, CEQA has been California's premier piece of environmental legislation. It has also, however, long been at the center of debate and controversy. Our first hearing provided some general framing with respect to the debates over CEQA. We listened to academic, policy, and legal experts regarding CEQA's impact, including both critics and defenders of the law. These witnesses offered different perspectives on some of the key questions in the CEQA debate. They also provided contrasting evidence regarding CEQA's effects. At the second hearing, we heard from 3 CEQA practitioners with extensive experience in CEQA and with different viewpoints on CEQA and the CEQA process. These witnesses discussed how CEQA works and shared their perspectives on CEQA and the current state of the CEQA process. They also discussed whether there are aspects of CEQA that they think could be improved and what changes, if any, they would like to see. Now, today, we're going to hear from 6 witnesses from organizations that represent California's local government. These witnesses will share local government perspectives on CEQA, on the current state of the CEQA process, and on where there might be opportunities to improve it. This hearing is part of a commission study designed to explore the debate that surrounds CEQA, examine CEQA's role in protecting the environment, and evaluate CEQA's impact. The commission will hold 1 additional hearing on CEQA on May 11. That's on May 11. I want to thank Commissioners Sidley and Aaroner for serving on the subcommittee for this study and for their leadership on this crucial topic. Before we get to the witnesses, let me just offer the usual bit of advice. Commissioners have read, if you submitted written statements, they've read that work. They are familiar with it. They, in all likelihood, have already formulated some questions that they will raise with respect to information presented there. So I would suggest that if you are interrupted, and I may do that during the course of your presentation, I'd like for you to consider that a compliment, because it means that the commissioners are engaged, they've reviewed the material, and they are in a hurry to get additional information from you. I would suggest that if you have written statements, that you maybe not read them. We've read them already, and you in all likelihood will be interrupted if that's what happens. This hearing was organized by project manager Tristan Stein. And now I'd like to ask Tristan if he would please be so kind as to introduce our first witness. Hi, Tristan.
Thank you, Chair Nava. Our first witnesses today are Nick Romo and Betsy Strauss from the League of California Cities. Mr. Romo is a legislative representative at Cal Cities, where he focuses on environmental quality. Mr. Romo was a policy consultant for the California State Senate from 2017 to 2019, a legislative policy analyst at Cal Cities from 2016 to 2017, and a legislative aide for the State Senate from 2014 to 2016. Mr. Romo graduated with honors from Pitzer College with bachelor's degrees in political studies and sociology. Betsy Strauss is special counsel to the League of California Cities, and she is also an attorney specializing in local government law with an emphasis on land use and municipal finance. Ms. Strauss has also served as the city attorney for the cities of Napa, Fairfield, and Roanoke Park. Mr. Romo, Ms. Strauss, you may please begin your testimony now.
Mr. Romo, I believe you are muted on your end and there we are.
All right, thank you. Thank you, Tristan, for that welcome. First, thank you for the invitation to participate in this process. I do hope it's the first of several dialogues on how we can collectively improve the cornerstone environmental law in ways that really acknowledge our growing, our diversifying state in ways that we can tackle the significant compounding issues that we face. Again, I'm Nick Romo with the League of California Cities. With me, Betsy Strauss, and we will both serve to answer questions and dialogue with the commission here today. Just briefly, League of California Cities was founded all the way back in 1898 to protect and advance local control, and both in the legislature, in the ballot box, at the courts, and with organizations like yourself. We also offer education and training to city officials across the state. I want to first express support for CEQA's core mission as a tool to promote smart, sustainable land use planning, and to do so in the most equitable and inclusive manner possible. And I think that's key. To say more plainly to the commission, support remains from cities for CEQA being a meaningful environmental protection law that serves as a balance check on development to ensure that the safe and healthy environment for all Californians. And I'll reconnect that back to the notion of equity and inclusion. But I think, as you've heard over the last few hearings, over its 50+ year lifespan, CEQA has really devolved its position as the cornerstone environmental protector to a much less unifying state of obstruction, litigation, and analysis paralysis. And we're hearing this from cities up and down the state. And as you heard from previous witnesses, from professors and practitioners, and as I would expect you hear from our partners in local government here today, the other panelists, cities too are trapped in what is becoming an ever more complex state of processes, traps, and abuses, frankly, by a suite of actors that, taken together, you have a chilling effect on projects that are critical to state and local priorities. And I would restate that, including local priorities, which are housing, clean energy, disaster prevention, and all the above. It's really becoming increasingly clear that for local governments, cities I'll speak for today, who are collectively aiming for a more sustainable, inclusive, and prosperous future, the status quo is not beneficial. We have heard that insinuations that we somehow benefit from the status quo. This is not our argument. Frankly, the law is not serving us well. And that's why we're at the table here today. We do think there is moments, a moment here to really make significant and significant change that we believe can balance protection for the environment, local decision making, and getting to yes on projects.
Thank you, Mr. Romo. Before I let you launch, I saw that Commissioner Sidley had raised her hand.
Sure.
But maybe she didn't mean it. Okay, I apologize. Please continue.
Sure. Thank you, Chair. It's been noted in the previous, in several different forums that under the current CEQA regime, saying no is safer or easier than taking on the gauntlet of CEQA itself. But really, what I'm here to say today as our first discussion is that this framework is actually antithetical to what is becoming enduring priorities for California cities. The League of California Cities brings together hundreds of local officials each and every year to set priorities. And for coming on more than a decade now, the priority as a whole has been to increase the supply and affordability of housing while retaining appropriate local discretion and other things such as protecting and advancing investments to support those who are experiencing homelessness, amongst others, including clean energy and disaster preparedness, as it relates to climate change and other state and local priorities. And the cities are really on the front line of the state's greatest challenges. And won't pontificate too much about this, but really in an environment in which there's plenty of blame to go around of why we're not building enough affordable housing, why there's not enough holistic solutions for supporting families and individuals experiencing homelessness, or why we're not more rapidly advancing clean energy solutions. CEQA has really placed cities in that proverbial rock and a hard place. So really, this one piece I will say is that what we hear from local governments and what I'd like to really pronounce today is that local government's role is to balance appropriate land uses, what we hope are reasonable arguments for and against a project, actual measurable and practical environmental mitigations that can be achieved for any project. And key really is to engage, bring along, uplift the communities that we represent and that are going to be impacted by a project. But really due to, as I mentioned, as you've heard maybe ad nauseum, is that the extensive, expensive, and exacting nature of CEQA today really does have a chilling effect on projects. It also has a chilling effect on local leaders and community trust alike. So it's not just on whether the project outcomes, but it has become a chilling effect on what the vision of local leaders can be for their communities, which include state and local priorities for housing, homelessness, and all the above, whether or not to actually engage and start to really put shovels in the ground to make those a reality. Now, I want to also say this, we can't put all the blame on CEQA. It's really one factor, which why projects are not being built. One of which is also that we need sustainable long-term funding for a number of these projects. But ultimately, in a fairly paints a picture that cities are blanketly opposed to much needed housing or clean energy projects. That's not the case. And as Professor Almendorf testified in a previous hearing to the commission, he noted in his testimony that while the chilling effect of CEQA is hard to quantify on projects known and rightfully so unknown, that sort of tip of what's below the tip of the iceberg, really, it is fair to say that in its current state of affairs, CEQA colors decisions and outcomes on projects of critical importance to both cities and state. And we could point to several cases, examples, and we're happy to provide commission staff additional examples here for the report and future discussions. We could point to specific examples where CEQA litigation prevented the type of projects that support state and local housing and climate goals. But we could also point to instances in which different courts have interpreted CEQA issues differently, leaving city officials with even less clarity and even more precarious positions to make decisions.
Right. All right. Mr. Romo, I'm going to interrupt you again because looking at the screen, I see Commissioner Sidley has her hand up and then Commissioner Garcetti. So Commissioner Sidley, if you would, please.
Thank you. So Nick, thank you very much for your testimony. And I certainly appreciate your opening statement about the how important CEQA is, how important it is to, take a breath, make sure you look at what's going on, make sure you do your best to protect the environment. And I appreciate that that is the view of the cities. I think, and one of the things I'm hearing from your testimony is, it's important, I think, for everyone to remember that when we start hearing about CEQA, we've usually heard about it by the time it gets to court. Otherwise, you're hearing about the procedure, but not to the extent that we're now hearing it in the news. And I think, Nick, for your members and for everyone to understand, if it's made it to court, I want to build on something that our commission president said, how important it is to vote. And so when these projects get to court, they've already been approved. And most likely they've been approved by an elected official. So it's extremely important that people vote so that they are a participant in the CEQA process and in the development process. But I think what needs to also be heard, and I think what you're saying about how difficult it is for some cities to know what to do, is that we then are looking for a project that's been approved by elected officials. And then you have a situation where people are spending tens, hundreds, maybe $1 million on a document to make it bulletproof. And I don't think we know what bulletproof means. I think that's what we're hearing you say. I think we're also hearing you say that all your cities want to do it right. They don't know necessarily how to do it right. And you can have somebody who has a valid reason or an invalid reason, whatever that may be, to take you into court as a city. You have no means by which to avoid going into court. And then you become, you've done all you can, you spent all this money, you're never bulletproof. What you are then is you try to become survivor proof. Can I move this forward? And I think that, I'm just trying to restate sort of what you're saying about how difficult it is for the cities. And I don't think it's really a judicial issue. I think the justices are and the courts are making decisions. But I think at the end of the day, and I'm curious about, this is a long way for a question, but it is, I mean, the courts are changing it, but do you believe that the law is not precise enough or written in such a way that you know what to do, so that when you get into court, you know what to expect, and therefore there's a role for the legislature to take a good look at this, to help cities, counties, states, agencies that are focused on this to make sure that we all know how to comply. Is that sort of where you're going?
Certainly, I think so. There is a role for the legislature, and we want to be partners with the legislature there. I think you've heard from other witnesses that there's kind of conflicts with existing state law on whether it be housing or streamlining for clean energy projects and CEQA. So then we're caught between the CEQA law as it reads, plus case law and new legislation that then we are again between that rock and a hard place, whether we either follow CEQA to its fullest extent of the law, or follow some streamlined proposal, streamlined process that is being laid out in legislation. I think in the current state of things, we're damned if we do, damned if we don't on these things. So I think Cal City's been working with the legislature and other things to really try to find some clarity there. And I think the other thing is that, in response to, and I won't go on too long here. I know other commissioners have questions, and I do have Betsy Strauss on the line with me, is that the legislature then, in frustration with CEQA, has then decided to, in many ways, sidestep CEQA because it prefers a much more streamlined process. But with that, you are also taking along local engagement, community input. And so we're really trying to find how do we match up all of those priorities. And I think part of this process here is that we think we can try to find a way where we can streamline things, but also include local governments and their constituents along the way. So,
Thank you. Commissioner Garcetti. And you're muted.
I'm unmuted now. Thank you, Mr. Romo. How do you do? I'll call you by Mr. Romo since you and I have never met. Don't know as well as one of my fellow commissioners, but thank you. Thank you for making the effort and putting your presentation together. And I listened carefully to what you were saying. I've read what you have written, but on one hand, you say, we need CEQA, we like CEQA. And on the other hand, you said, but the law is not helping us. It's not helping us in a way that we can move forward with what the underlying theme is for this. So I was waiting for you. Okay, now here are at least 3 bullet points in terms of if you could do 1, 2, 3, 4, 5, 6, 7, whatever it is. These are the things that I would love you to look at, and the cities would be thrilled if there is something from the Little Hoover Commission that addresses those issues.
Oh, that's Thank you, sir. Long time admirer. As a resident of the city of Los Angeles. If I may, Chair, I think that's where I was going.
Okay, good.
Perfect.
Okay, well, so I will fast forward a bit here and I'll leave it here. And we really encourage the commission to take a look at a couple of things. On the matter of litigation, we do encourage changes to the timeline for notifying cities of objections to CEQA documents, also known as exhaustion of administrative remedies. So in order to challenge the city's CEQA decision, a person must present their objections during the CEQA public comment period or prior to the close of a public hearing on the project. Really what this means is that objections can be raised even after the public comment period is over and even shortly before the city is prepared to take action on the project. This has caused significant delay in project approvals. So we do recommend that we require all objections to be presented during the CEQA public comment period, unless the problems were not known or could not have been known with reasonable diligence during the public comment period. We think that this would really streamline things and prevent what we sort of these last minute document dump pieces of litigation that's holding us up. So that's one recommendation. And please interrupt me, commissioners. On the issue of streamlining projects even further, we do recommend changes that would help us to rely on previously approved environmental impact reports, the EIRs. CEQA does allow cities to rely on a previously approved EIR for a project that is consistent with our specific plan in that area, or a project that is consistent with a community plan, general plan, or zoning. However, the law requires additional environmental review if new information is available or there are circumstances external to the project that have changed. We do recommend allowing for reliance on that previously approved EIR without the considerations of new factors if a project is approved within a reasonable short time period from the certification of that EIR. So basically, we've done the EIR. If it's within, and we need to discuss as public policy experts here about what reasonable time period is, but within reasonable time in which I've adopted that EIR, I can go ahead and move forward with that project. And then lastly, there's plenty, and I'd like to submit this in writing to the commission, but we also believe that when it relates to the CEQA requiring us to do alternative site requirements. So when a project is brought forward, we have to determine different alternative sites for that, and many times it's held us up. We are advocating for the elimination of the alternative site requirement for all the private projects. We think we should be able to move forward with those projects, and I think that will definitely help with housing construction. So I'll leave it there. I believe I've exhausted some of my allotted time here. Betsy Strauss, our legal counsel here, who's a tremendous expert, and myself are here for additional questions and get engaged throughout the hours.
Yeah, I want to thank you for making reference to Ms. Strauss. I didn't want her to feel as though we were ignoring her,
No.
But it was my understanding that she joined you in case there were questions that you couldn't answer.
Yes, sir.
And so I would take that as a representation of her skill that you have been able to answer those to our satisfaction.
Yes.
So we appreciate you being here, Ms. Strauss. Let me turn it back to the commission to see whether or not there's any further questions or comments. Commissioner Aaroner, are you right? Okay, you're up.
Yeah, right. And actually, this is personal. Betsy, I think I've known you from Los Angeles.
Yes, absolutely.
Yeah, okay. I
Nice
just
to
wanted
see
be
you.
sure of that.
Thank
It's
you.
good to see you too.
Nice to see you.
Really.
Thank you.
Yeah.
Yeah,
Thanks for being here today.
absolutely. Thank you for having the hearing.
Thank you.
Thank you,
Commissioner Hernandez? I saw it. Yeah.
I thank you to both being here. Quick question. I mean, I've been looking at different reports on costs, kind of board costs. Do you have estimated costs in terms of to the cities and counties in terms of just in aggregate? I saw that in 2004, it was about 100 million in terms of some of the CEQA reviews.
I don't have that, Commissioner. I'm not sure we've updated. Betsy, do we have anything on that? But it's something maybe we want to explore in collaboration.
Are you asking, for instance, what an EIR might cost to prepare, or?
The cost borne on the cities and counties, yes.
Yeah, we'd be happy to get you that information. It's certainly a combination of the documents themselves and then the litigation costs, which actually does sort of funnel into one of the things that we would like to see, which is the possibility of, attorney's fees for local governments under certain situations, under certain circumstances, which is now not available.
Thank you.
Yep, thank you, Commissioner Hernandez. That's a good question. And so that information you'll be good enough to put together and provide to staff. I see Commissioner Sidley. You have your hand up?
Yeah, I just wanted to say to Betsy, is there anything in particular from your position as an attorney specializing in this that you want to add? I mean, you did just add now that a provision for attorney's fees, maybe for a city for prevailing party, something like that. Is there something else that you'd like to add? I want to make sure you have an opportunity.
Thank you. I appreciate that. I would like to just respond to something that you had said earlier, which is that I think generally cities think they have some sense of the understanding of what the law is. And although we certainly hear about the cases that cities lose, of course, and those are the ones we are concerned about and then get confused by. But generally, we understand what the law is. The difficulty, I think, the biggest difficulty for us, I think, as cities, is how easy it is to challenge a project approval based upon CEQA. Sort of the procedural ease that Nick spoke to in terms of changing the exhaustion administrative remedies. The difficulty of, for instance, getting a court to require a bond of plaintiffs who sue. The unavailability of attorney's fees. So getting into court, as you well know, I'm sure all know, is not so difficult. And so we think we may know what the law is. We think there's substantial evidence to support our findings, but then we get sued. Then projects are way delayed. And then the housing is not constructed because at this point, the developer has walked away because it's just too difficult. So just to answer your question. And then I think the second thing I just would offer is, and Nick touched on this, which is that we are caught as cities between CEQA and the approval of housing. And where that shows the most is the Housing Accountability Act, which says you may not disapprove housing, except for certain circumstances, as you know, and you must do CEQA. And you must make the findings under CEQA. So what do you do there? As I'm sure you know, we've worked for several sessions, including this session, to try to sort of sit at that intersection and try to stop the crashes from occurring, between the two. But that's a major challenge, at this point.
So
thank you.
And Betsy, thank you for that. And I want to thank you for being more precise about my language. I do think we all know, what we're supposed to do. But I will also say, even if you do it, you're still going into court. And that's why I sort of said, well, we don't know what to do. We don't know what the law means to try to avoid going into court, because we don't have the tools in our toolbox to say, we dotted every I, we crossed every T, we've turned in a 6,000 page document with, 10 megabytes of charts and graphs behind it to support. Then it goes to the elected officials, they approve, and then someone comes in and will take you into court. And then you start that process, and you sort of start at the beginning. And as you say, no attorney's fees, no bond. And one of the things of building anything, housing or whatever, is the financing. And at some point, the bank's going to walk away, the developer's going to walk away, and then something that a city, county might have thought was important for their community, for a reason that you may be ultimately successful on CEQA. And the problem is of the time that it took, that you still lost your project. And so again, I appreciate you again clarifying my words. And I also, the starting point is the cities are supportive of CEQA. The cities are supportive of, looking at the environmental impacts, doing the mitigation measures. But how do you then do it all? And I think that's the question that we're all pondering right now. How do you balance it all so that things continue to move forward? So thank you very much. I appreciate that.
Yeah, thank you.
Thank you. I saw Commissioner Byer had his hand up. I don't see him on the screen. So if he wants to come back before we let these witnesses go and move on to the next set.
Mr. Chairman, I will check with him now and see. I don't know if he had a tech problem or he just had to leave, but I do not know. I'm texting him now.
Okay. Well, I don't want to hold up. We have other witnesses as well. So let's move on. Let me express appreciation to both of our witnesses for your testimony. Thank you for being so generous and for being willing to provide us and staff with additional information after the hearing. So if you would be so kind, Tristan. I think we have another set of witnesses. Thank you.
Yes, we do, Chair Nava. Thank you. Our next witnesses are John Kennedy and Arthur Wylene from the Rural County Representatives of California, RCRC. Mr. Kennedy serves as a policy advocate for RCRC, where his portfolio includes solid and hazardous waste, energy, CEQA, and other issues. Prior to joining RCRC, he served as a consultant on environmental issues in the State Assembly for 12 years. Mr. Kennedy holds a JD from University of Pacific's McGeorge School of Law, a master's degree in public administration from USC, and bachelor's degrees in history and political science from CSU Bakersfield. Arthur Wylene serves as general counsel for RCRC. Prior to joining RCRC, Mr. Wylene served as the appointed county counsel for Tehama County from 2012 through 2017, and as deputy and assistant Tehama County counsel from 2003 through 2012. He is a 2002 graduate of New College of California School of Law, and a former law clerk for the California Supreme Court. Mr. Kennedy, Mr. Wylene, you may please begin your testimony now.
There we go. Always forget that. Thank you very much. Good afternoon. John Kennedy with RCRC. Briefly, we are a 40 county organization representing 40 of California's 58 counties. Our populations are between 1,100 and 500,000 people. And I'd like to issue a disclaimer. The views we express are our own. They're not the views of our individual county members. And I won't attempt to cover all of the topics or issues contained in our written comments, but do want to touch on some of the highlights. The first of which is evolution of CEQA over the years. Counties as local governments really have been on the forefront of CEQA implementation as both project proponents and as lead agencies. As you stated, Commissioner Nava, many view CEQA to be one of California's flagship environmental laws, which it is, and others justly criticize it for creating serious impediments to development. CEQA is a very powerful information dissemination and environmental mitigation tool, and we strongly support both of those objectives. But at the same time, it has expanded into a very complex regulatory obligation with very serious consequences that result from procedural and substantive missteps. It's rightly criticized as a litigation trap by many that can be exploited for competitive gain or to stop projects altogether. And previous witnesses testified to the number of CEQA cases filed each year, but I think far more important than that is the ever looming threat of litigation, the costs and multi-year project delays that will result from those. And this has resulted in the preparation of much more complex environmental review documents in an attempt to bulletproof the environmental review process. We've provided an example of how long EIRs have become over the year, from 188 pages for an 83-unit housing project in San Francisco in 1975 to over 1,600 pages for a 35-unit project in Contra Costa County in 2018. And I'll also point out that the simple threat of litigation is often enough to make project proponents more than willing to make concessions to avoid legal costs and delays. And in some cases, these are to the detriment of public good. Housing projects often shed a significant number of planned units during this environmental review process, which ultimately makes it a lot more difficult to achieve California's housing supply goals and overcome the tremendous housing deficit. Briefly touching on CEQA misuse and abuse, CEQA is often used as a tool by business, labor groups, and NIMBY groups to either stop competitors, extract concessions from project proponents, or delay projects past the point of economic viability. As local governments, we sometimes get caught in the middle of these disputes, including in the context of solid waste enterprises, where one enterprise may challenge another enterprise when we're looking to award an exclusive franchise agreement to someone else. And it's here where we agree with the league that the award of attorney's fees only to a prevailing plaintiff becomes a real problem. Many assume that CEQA compliance and litigation costs are borne by wealthy project developers that are proposing projects. That's just not true. Because of CEQA's extensive reach, in many cases, there is no developer, and the local government itself is the project proponent. So when a business sues a local government under CEQA to frustrate a competitor, it's the local government and its taxpayers who ultimately pay the bill, regardless of whether they win or lose. And this becomes a real challenge with CEQA's numerous angles of attack and low thresholds for prevailing. With respect to CEQA reform and streamlining, the legislature spent a great deal of time over the last decade on streamlining and reform measures that really impact only a handful of arenas and mega projects. And it's also had to respond rightly to recent court decisions that jeopardized university housing and admissions processes. But these are really merely treating the symptoms and not the underlying problem, which is CEQA's complexity and legal uncertainty. And we agree that it seems like there's often a tension between CEQA and some of the state's other compelling policy goals, including housing production, water supplies, wildfire risk reduction. On a side note, and something that happened this week, the legislature just considered in the last 7 to 10 days, half a dozen measures that seek to address multi-year delays in connecting housing and commercial projects to the electrical grid. One of the measures was gutted, and that measure would have been really instrumental in expediting project completion. What was gutted was a narrow CEQA exemption for electrical distribution system upgrades. As a result, the only CEQA reform that was actually moved through that process was a piece that requires the state to complete CEQA documents within 2 years. And a 2-year process for merely preparing environmental documentation really isn't compatible with the urgency with which the state needs to react to emerging problems.
Mr. Kennedy, let me interrupt you. I apologize. Commissioner Byer has his hand up.
Thank you, Mr. Chair. Can you hear me?
Yes.
I'm trying a headphone thing, so I apologize if I lose connection. My question has a predicate, and the predicate is in our last hearing, one of the witnesses used an analogy that CEQA is like an iceberg, which it struck me as the wrong analogy. They were trying to make the point that only 195 cases are litigated on average every year. But at least my theory of icebergs is that the area below the water can be just as dangerous to ships. So I didn't think it was a great analogy, but what I'm trying to figure out is what the right narrative is, because each of the witnesses today and in the past have sung the praises of CEQA as a measure of improving the environment. And then half of them have gone on to criticize it as a litigation creator or as expensive or deterring ability to secure state goals like housing. And what I'm trying to think through, and I don't have a firm view on this, is how to balance a CEQA reform effort with the political realities that CEQA is not going to go away. Most people think it's very useful most of the time, but how do we improve things? And so my question relates to your attorney's fees recommendation. I raised that at the first issue, and the witness responded correctly, in my view, that it would deter litigation, that is, particularly nonprofit groups, et cetera. So just to be clear, are you proposing that fee switching or burden shifting on attorney's fees only apply with respect to governmental entities and not developers? Is that what you're proposing?
So I think those are probably some of the most compelling cases to award attorney's fees to prevailing local governments. At the same time, I think we would actually suggest that the court be given a little more discretion on when it is appropriate to award attorney's fees. Certainly, we don't want to chill the ability for righteous interest groups to challenge projects to make sure that project impacts are effectively mitigated. But at the same time, when some of those challenges are raised for, I can't say purely competitive purposes, but virtually purely competitive purposes, those opponents should have some skin in the game. And I think it's a tremendous burden for locals to bear to not be able to recover those costs at all in the process. With respect to the iceberg, I think it is kind of a good analogy here. We only really get visibility of those few cases that are actually litigated. There is a much bigger problem under the surface in terms of the actual prep work that goes to try and avoid litigation, to make concessions to those who may bring challenges to actions, and just all the uncertainty that results. Unfortunately, it's a lot harder to quantify all of that. So it's the great unknown that could be just as dangerous to any individual ship trying to weave its way through the CEQA process.
So the related question is, it seems evident that since 1970, science has progressed. And so it's not surprising that environmental impact review documents have gotten longer or more expensive. But what I can't really understand is why they have become a trap for the unwary. And you pointed to one example, which was prohibiting comments unless there's some extraordinary circumstances and new facts. If you just took that single reform, would that have a material effect on the timing or cost of CEQA implementation? Or is that just part of what has to be a larger mosaic of 5 or 50 other things?
I think it's one of many different things that need to be accomplished to really get at the heart of some of the CEQA challenges. It's going to be the process by which people raise objections, and hopefully those objections get resolved during the public review process and not through subsequent litigation. It's also going to be in the remedies that are afforded. The King's Arena and the Capitol Annex building got some nice relief from injunctive relief provisions thrown into the statutes. Those could be incredibly helpful to keep other types of projects on track while you go through and figure out what went wrong in the mitigation analysis and mitigate those impacts. But I think perhaps one of the biggest changes that could make a fundamental difference is CEQA hasn't really been reconciled with the large body of environmental law that's developed since 1970. There are so many benefits that have resulted from ARB's technology forcing and transformative regulatory requirements that they've adopted in the vehicle context, in the off-road, on-road diesel equipment context. But CEQA really doesn't seem to care much about that. And so I think Arthur was going to speak briefly about the real need to reconcile CEQA with some of that existing statutory and regulatory law that's developed.
Thank you.
Hi, yeah, this is Pedro. I was just going to say, Mr. Wylene unmuted himself and just seems barely able to restrain himself. So got something there. Go ahead, please.
So no, I've been told that I'm not always terribly subtle when I have to share it. Let me first respond to kind of a question that Commissioner Beyer had posed, which is, really what are some of the reasons that CEQA has become kind of as complex and as maybe difficult to get our hands around as possible. And John alluded to one of them, but I'd like to maybe start with one of the others. Certainly, the impact of public comment and the needs to respond to public comment are a part of it. I don't know that they're the largest part of it, however. Science certainly very much has evolved over the last 50 years. But I think also that understandings of the sort of or at least the practicalities of the purpose of CEQA, I think have evolved in ways that don't get talked about a lot. I think the original concept behind CEQA, very similar to the concept behind NEPA that it was patterned after, is essentially as a mechanism to give public officials the information that they need to make good environmentally balanced decisions and to identify those mitigations that are feasible. And I think that requires obviously a certain level of disclosure. It also requires a certain level of understandability. What it doesn't require is 15 volumes of technical studies. Unfortunately, CEQA has really evolved in a lot of ways to be a bit of a paper chase. When you're drafting a CEQA document, I've been involved in many of them. Pretty much the last thing you're thinking about is, can the elected officials understand this? What you're thinking about is this going to, have I incorporated the latest case law or predictable evolutions in the case law with regard to how a particular impact is going to be viewed or evaluated? What arguments could possibly be made? How do I armor this up? It's you're attempting to avoid litigation, not to inform the elected decision makers. I think that's one, a lot of what generates the additional cost and length. And two, I think that's the uncertainty. I've worked with Betsy on the previous panel a lot, and I will confess she often knows better than I do. But one area that I think warrants a little bit of view is the sort of uncertainties that go into CEQA. Legal certainty is, at least in theory, supposed to be a norm of the common law system. And I think CEQA is one of those areas where it really does not exist, or at least does not exist as it should. One of the things we consistently see with CEQA is kind of a continual and often unpredictable evolution. One of the, I think, recent examples, at least for those who float around the Sacramento circuit, is the Save the Capitol litigation challenging the Capitol Annex renovation. One of the things that the majority in that court held was that the EIR's failure to include a grade level representation of what the Capitol was going to look like, a visual representation, was a flaw in their aesthetic impacts. I don't know too many practitioners who saw that one coming. Such a thing has certainly been seen as desirable in the past, but the idea that CEQA required that and that your EIR could be set aside because you didn't do that, I don't think was super predictable. That's the kind of thing that's not just a concern when it happens, it's a concern when you're trying to draft environmental documents and produces caution, produces cost, produces delay, produces all of those things that you see out there. So it's really, I think that's probably a large key to a lot of the underlying things that we see, is simply that level of uncertainty that CEQA has engendered, partially because of how it was drafted, partially because of the breadth, and also because it's kind of developed, CEQA really has developed its own attitudes, mystique, kind of almost a common law, if you will, that really encourages both broad claims and broad rulings that I think go fairly far beyond, what certainly what was anticipated in 1970, and even indeed what we can anticipate today. So anyways, that wasn't what John asked me to talk about, but I couldn't restrain myself, so I thought I'd go ahead and share that. So in terms of what John actually did want me to kind of touch on briefly is the interaction between CEQA and California's very broad suite of environmental laws addressing a variety of contexts. I mean, California has some of the most protective, aside from CEQA, some of the most protective environmental laws in the country in some areas, and probably in some areas, some of the most protective laws in the world. And these laws, obviously, they're independently enforceable through some means, and they necessarily function as a floor for environmental protections. Now, of course, CEQA touches these areas as well. I mean, CEQA is immensely complex. It's very, very broad. It touches every conceivable impact and indeed touches things that we might not have necessarily recognized for impacts, like noise from students. I mean, I kind of know that's a neighborhood impact, but a CEQA impact was kind of a bit of a new thing. And right now, because these laws set the floor, we have a situation in which CEQA either always requires more or can always be argued to require more. And that's really where you get into this sort of legal uncertainty. Okay, I've done my water supply assessment. I've gotten my 1602 stream bed alteration agreement, if we're talking about something out in the boonies. I've done what I need to do. What more does CEQA require? I think that if we're really going to pursue reform and pursue some level of certainty in this area, I really do think we need to have a discussion about whether there are circumstances in which compliance with either existing standards or a set of standards we develop is not merely the floor, but it is the ceiling. It is sufficient. Now, I don't know, there have been obviously proposals to do that in the past in various forms. I know some prior witnesses have spoken about those. And I don't think that necessarily any individual one of those proposals needs to be relitigated, so much as I think we need to talk about the concept. Are there areas where we can, where we should, where we must identify a set of standards, negotiate them in advance, and then provide that is sufficient. If you do this, then that impact is, shall not be deemed a significant impact for purposes of CEQA, or CEQA is satisfied, however it is you want to phrase it. Now, I know that some of the previous witnesses have kind of poo-pooed that idea a little bit, said they kind of pulls out the bricks from the foundation of the edifice of CEQA, I think was one of the more colorful comments on that's in the record. But I really do think that sort of begs the question as to what is the foundation of this CEQA edifice? What is the basic task that it should be doing? Is this really a mechanism that's designed to allow elected officials to make good decisions about with the environment in mind and provide good mitigations, or is it really just a mechanism for folks to get from the court kind of a set of policy proposals that sort of ever evolves and are things that they couldn't get from the legislature? And I think that's really where I think CEQA has become the latter. And I think any reform needs to look at CEQA maybe trying to be a little bit more like the former, be more user-friendly for the elected officials who have to make the decisions, and provide a little bit of certainty that as long as a reasonable job has been done and the elected officials have made reasonable, environmentally aware decisions, that will be deemed good enough. I think that certainly attorney's fees reform is in changing the incentives for CEQA litigation is a big part, but also changing the level of certainty about whether a decision will be upheld is also, I think, a big part of the conversation. So thank you very much.
Thank you.
If I could, I'm sorry,
Mr. Kennedy, go ahead.
I just also wanted to touch on another enormous issue that's reared its head in rural context under CEQA, and that's vehicle miles traveled and requiring the use of VMT to measure and mitigate a project's transportation impacts. It doesn't work in rural areas. We're a truly diverse state, and rigid one-size-fits-all applications aren't going to work. So LA County, 10 million plus residents, 4 other counties with over 2 million residents, but we have 19 counties with fewer than 70,000 and 8 counties with fewer than 20,000 residents. Density is very different across those jurisdictions. 7 counties with over 1,000 residents per square mile, but we have several counties out there with less than 10 people per square mile. SB 743 brought us the VMT, but called for OPR to develop the VMT within the context of transit priority areas. They decided to expand that statewide over quite a few objections. And I think our concern is that may be a useful metric to evaluate those transportation impacts in dense urban areas, but it doesn't translate well, because our homes, businesses, and services are located much farther apart. That's just the reality of life in rural California. We're ag-based, we're forestry-based. Our homes, our communities, our services are located farther away from one another because of those realities. And so the traditional opportunities to reduce VMT, like transit, increased walking, biking, shifting to infill development, they're really not going to work because we don't have the resources, we don't have the economies of scale to make transit workable, and the rest of them just aren't applicable in rural settings. So we strongly encourage the legislature, the administration, to go back, make it an off-ramp so VMT doesn't have to be used as the transportation metric in rural areas, and also take an opportunity to look at a lot of the existing CEQA exemptions, both statutory and categorical. Make them useful. Don't make them cluttered up with exceptions that none of them can be used, or that open up pathways for people to argue and challenge a project that the CEQA exemption really shouldn't apply. And so I think those are some of the other big suggestions that we would have going forward.
If I may, Mr. Chair, John's reference to the vehicle mile travel standard, I think, provides another illustration of some of the sort of legal adventurism that I think we've seen as CEQA doesn't just get evolved through the legislature and the resources agency, but also through litigation in the courts. So as John indicated, due to changes in the CEQA guidelines, the way we evaluate transportation impacts was shifted from the old way, which looked at the level of service, basically how bad is the traffic on the road and how much worse is this project going to make it, shifted over, at least in theory, to looking at how many vehicle miles traveled does the project generate, which, as John has indicated, in rural areas that has its own set of problems. However, as with most things, all this did is reset the floor rather than affecting the ceiling. One of the things we've noticed, and I participated in a CEQA panel, MCLE panel last December, in which this was discussed kind of in detail, is that in a lot of areas, we are now having to do both a vehicle miles traveled analysis for our traffic impacts. And now, thanks to the arguments that we're seeing in comment letters and in litigation challenges, we're having to do the good old school level of service analysis under the guise of wildfire evacuation. So, again, rather than actually changing the standard, all this has done is kind of, move the bar up for where the floor is. Not as the result of changes the legislature made or even changes the resources agencies made, but due to basically arguments that we're seeing in comment letters, litigation threats, and ultimately litigation. It's kind of that sort of legal adventurism is really what's driving the evolution. So even things that are supposed to be changes by the legislature really just turn into additions, more burden, more cost, more delay, more uncertainty, and more litigation.
Thank you. Let me check with the commissioners. I do know we have two other witnesses that are on deck, but commissioners, any additional questions? Commissioner Arner?
I didn't want to, it wasn't so much a question as a comment. If I remember correctly, in our hearings around green waste,
yep,
the vehicle miles was a huge issue as well with testifiers there, particularly in rural communities where trying to pick up trash, right? And going down a driveway that could be a mile long and it's dirt, that kind of thing. So I think it's just interesting that it's linking up to other things that we've been considering at this point.
Yeah, I would agree with Commissioner Arner. I think that this commission has been somewhat sensitive to the one size fits all, doesn't really fit, particularly with respect to rural counties. And part of the difficulty that you're confronted with is when you have a majority of the legislatures who live in metropolitan areas, they don't get out much, and I'll probably get in trouble for saying that. But to have real experience, and I say this because I was fortunate when I graduated from law school 100 years ago and I took the stagecoach to Fresno, I spent a number of years in Fresno County and got a sense of what it was like if you had to travel to Reedley and Sanger and Coalinga. And then I also spent some time in Texas where, the closest town was 70 miles away. So there are a whole constellation of considerations that need to be baked into a discussion of when you apply rules and regulations to rural areas that make it different from downtown Los Angeles. So let me express my gratitude to both of you. Thank you so much for your perspective. It will be very helpful to us in formulating our recommendations.
Thank you for the opportunity.
You're very, very welcome. Thanks for joining us. Tristan.
Thank you, Chair Nava. Our next witness today is Lorelei Oviatt. Ms. Oviatt is Director of the Kern County Planning and Natural Resources Department. Ms. Oviatt has years of professional planning experience in the public and private sectors with a focus on project management of large-scale multi-agency planning and moving extremely complex projects through the system under accelerated timeframes to streamline business permitting and support quality of life for communities. Ms. Oviatt has a bachelor's degree in sociology from Baldwin Wallace University in Berea, Ohio, and a master's degree in public administration from CSU Bakersfield, where she is also an adjunct professor in public administration policy and urban planning. Ms. Oviatt, you may please begin your testimony now.
Thank you so much for having me, Chairman, members of the Commission. You have heard a lot of testimony, so I want to use my local government opportunity here to bring up a suggestion for you to consider. You also have my written testimony. The complexity, which has been, talked about, is really at the level of planners. And in order to educate people on how to do these documents is very complicated. But I do want to say that our #1 goal is to write our documents so that the public does understand them. I appreciate that the lawyers who may testify are focused on the legal, but the planners are educated on the purpose of CEQA, which is to disclose what we like to call the good, the bad, and the ugly. Every single thing that a comment brings up, whether you like it or not, should be in your documents. People's opinions matter, and they are the people on the ground who have to live near these communities. They are the ones that have to actually experience the air, deal with cultural, tribal issues. So documents by their very nature have gotten bigger. But let's remember that we're supposed to do this as a disclosure document, and then elected officials balance that with the social equity, the economic development, and the other goals that the state of California has put together. Kern County, we provide 60% of the wind and solar and your green electrons. I doubt if there's a commissioner here who flips a switch who doesn't have Kern County green electrons. And every single one of those projects had to be an environmental impact report because of cumulative impacts. So we just committed to doing them faster and better. I don't think there's any other county that does 10 to 14 EIRs a year. That's 156,000 acres of these things, and it's cumulative impacts. And in the case of renewable energy, very few of them are sued because people like those projects, but we do have to work out various issues. So one of my recommendations that I want to bring to you is there are various project types that the legislature and Sacramento and policymakers have made, I say, more important than others. Housing, for example. And I gave you a long list of exemptions and complicated ideas. But renewable energy is another one of them. And so one of my suggestions is, when I say vehicle, we like to say in the department, look, there's only so many vehicles. There's an exemption, there's a mitigated neg deck, or there's an EIR. That's it. Or you adopt an ordinance that makes something ministerial, and then you don't have to do any more. We need another vehicle. And when I brought up aesthetics, I didn't bring up aesthetics because of the capital. I brought up aesthetics because of commercial scale solar. Every single commercial scale solar that takes up thousands of acres, there's no way it doesn't trigger an environmental impact report because you have characteristically changed the view shed. And the question is how important now is aesthetics? Perhaps it was important in 1970. How important is population growth? There are 21 categories. Are they all as important as all the rest? If we only have limited time to actually implement our solutions for housing, climate change, economic development, and disadvantaged communities. And we are one of the poorest counties, and we are clearly being forced into an evolution, and we are moving through it. But we cannot ignore any category. Aesthetics is just as important as air quality, it's just as important as biological, it's just as important as cultural. So I say that I have been participating with CEQA since 1974, and I am ready to say it is important, but we need to figure out how to move into the future and give us some more tools. That's number one. You saw in my testimony, when I say judicial interpretations, I am more than ready for my CEQA judges to judge me. I want to be judged if that's where we're going. It is when they substitute, which my judges don't, but when other judges substitute their opinion on the value of the project. That is not what the CEQA litigation is supposed to be. I'm being simplistic here. The legal standard is, did I follow the rules? Did I follow the process? Did I implement the law? Not some novel new arguments. I could take all day telling you all the novel arguments that have been presented to me in the varieties, given the hundreds of EIRs that this department has done. Some of them are very novel, but they're not law. They make law. It's up to the legislature to make law. It's up to the California Supreme Court to make law. And to a limited extent, it's up to the appeals court to make law. It is not up to superior courts to make law. And that is the kind of grappling that we are required to do at a local level. And I'll be honest and tell you that many, many smaller cities and counties just go into paralysis. It is not that they don't want to move these projects forward, but the endless conversations with their legal counsels, with all due respect to anyone who works for applicants, I take the legal advice from applicants only so far. They are advocating for their clients. They are not always advocating for the public. So I'm interested in their expertise.
Mr. Chairman, you're muted. Mr. Ch
You think I'd know better by now. But Commissioner Byer has his hand up.
Yes, thank you for your testimony. And my question relates to testimony we heard in the first and second hearings about environmental justice. And I'm going to overstate it just to make the point. Several witnesses implied that CEQA was not the only, but the predominant way in which underrepresented communities, particularly communities of color, could overcome a legacy of racism and neglect. And they pointed to very compelling examples. And I noticed that the Biden administration last week, the president issued a new executive order on environmental justice. As we proceed, do you have any recommendations about how we make sure that we're not embedding in place a series of assumptions about economically disadvantaged communities, and that we're doing something to improve their voice, their ability to participate in the conversation about the environment without unnecessarily creating more delay or expense?
Thank you. I think that's an important question. Given that environmental justice is about environmental impacts, but it's about a whole raft of other things, redlining for mortgages, other sorts of things that CEQA does not address. I don't think it's exclusively that CEQA can fix it, but I think there's a long list of things that are important. Air is one of the most important that comes up. Noise is another one, which is one of the most complicated things in CEQA, to be straight about it as a practitioner. It's not always clear what the standards are. But at the end of the day, I have heard a lot of propositions about limiting public testimony. I just don't think, as a practitioner and as a representative of local government, that this is the direction to go. Limiting public comment. Here in Kern County, you know, I know there's a review period. As you all know, we send out the EIR and it says 45 days and it says, we'll take comment right up until the board votes because we believe that is the law. We don't believe the law says that you can limit public comment to the 45 days, although there are some jurisdictions that try. And the question becomes, at that point, it's not about limiting the comment of people. It's when does it end? So I think there is some place, for example, we have routinely gone to a planning commission and then go to a board hearing. And the night of the board hearing, someone dumps 10,000 pages, without an exaggeration, of comments. Now, because we are experienced with this, we answer the comments. We answer the comments in the process. If my staff has to stay up all night, we'll stay up all night and charge the applicant, but we will answer the comments and we'll look to see, is there something fatal in those comments that we do have to continue? That is a delay in contact. Most environmental justice representatives from a community are not putting 10,000 comments in. That is not what they're doing. That is a different, coming from a different world. I have had people go to the internet and download things in Dutch, in all sorts of different languages. We have honored that and translated it. Where does it end, however? Where does the legitimate public comment and the green mailing end? And I am certainly, by the way, I want to give you a different idea. EIRs are not bulletproof, they're flak jacketed. Okay, there's no bulletproof here, but we do the best we can to make sure that we don't overlook any comment. No matter what we think of the comment, we want to answer your comment. Now, from your point about science, that is true, but the science does evolve and the internet has changed everything. So it's really the internet that has changed CEQA comments, because you can go at 2 o'clock in the morning and download a report, even if you don't know anything about the report, and put it in the record, and we have to honor it. So I think it's these end of the hearing attacks. Should
Okay,
someone
thank
be
you.
able to show up at a hearing when it took me a year to do this, and they've been on the list, and dump 10,000 pages at 2 o'clock in the afternoon at a hearing? That's the thing I would ask you to look at.
Thank you. I just saw Commissioner Hernandez was unmuted. Now he's back to mute. Do you not want to?
It was kind of related. Yes, go ahead. You just reminded me last hearing, there was a comment about sanctions, about individuals that are willfully trying to delay the process. I mean, yeah, could you expand on that? I mean, it sounds like it's related in terms of someone willfully trying to submit something. I mean,
Yes,
something we should look at, like a sanction.
I think I don't know who that comment came from, but truly, it is difficult for local government or elected officials to become the arbitrator of people's motives. And that would be my concern.
Yep.
Right? For example, there have been people who said, well, if you don't live in the neighborhood, maybe your comment doesn't matter. I think those are the kinds of things that make us a less than society. If you have comments, you should come bring them.
Commissioner Sidley?
Just to help Commissioner Hernandez out, and it's a pleasure to meet you, and I look forward to meeting you in person. That was a one-off. It was a case. It was a CEQA practitioner who brought a case, and ultimately the courts found that it was not brought in good faith after numerous pieces of litigation. It is not something that is very common at all in the CEQA process. I mean, I think to Mrs. Oviatt's point, most practitioners welcome every comment. It is about public disclosure. It is about public participation. I think what it is more is what you're hearing is it fair, I guess, to put a term out, that after you've done all this work and you've put out your draft and you've waited for those comments and you respond to those comments, which the law requires, and then you go to the hearing and then all of a sudden there's all new stuff. And I will submit to you that the comment period in the law is 45 days. Often on very complex projects, that's given more time, 90 days. Generally, you'll see people who find them to be very complicated, that they'll come in and ask for additional time. I think a lot of agencies will give that additional time to make sure that people have time to read the document. And I will also submit to you, as we heard at the beginning of your testimony, it is very complicated material. So to make it so that anyone can understand it it's the rules of people writing law now in just plain English as opposed to legalese. This is that on steroids, because you're studying things, noise, which is very complicated, air, you're talking about air mod, different modeling, and candidly, junk in gets junk out. But at the same time, you make so many decisions to just put something in that, and I would also submit to you that every government person that I have worked with has come into this process wanting to desperately do the right thing and wanting to do it right and listen to the concerns and mitigate to the extent possible. I don't come with a conspiracy theory that somebody's trying to hide the ball. That's not my vision, and that's not my understanding of government employees. They want to do the right thing. So my 2 cents, but that particular issue comes out of a case, and it's pretty much a one-off.
Thank you. Ms. Oviatt, before we move on, do you have other suggestions for us based on your experience?
So one of the suggestions is, the definition of a project has expanded over time. And even though there is a definition in the statutes that clearly states that studies are not, that is not what the courts have interpreted. So this is the issue of, when a government agency wants to apply for a grant, for example. This comes up all the time. I have people calling me up at the planning department. What is the CEQA? I said, well, you haven't done anything yet. I don't know what the CEQA is. The state agency require for them to, or the Department of Energy or anybody to give you a grant that you have to send them your notice of determination or your notice of exemption. But we didn't get the grant to design the project yet. So we do what we all do is we kind of work our way through the issue, and we say that taking it to the Board of Supervisors to ask for the grant is exempt. But that's not really what the state agencies are looking for. They're looking for the ultimate. So I just think, as a simplifier, could we hone in more on what an actual project is that requires review under CEQA? In regards to, we analyze it when we get closer to the shovel, is what I like to say. And when they say, well, you know, the government is taking an action. Yes, but there are many times that elected officials commit money and then nothing's ever built. There's a variety of different reasons. Maybe they didn't end up with the money or something happened. Why are they being forced to do an EIR? You know, listen, even the cheapest mitigated neg deck is $80, $90, $150,000. There's no $30,000 mitigated neg decks anymore. And so at that point, it slows everything down is where I'm going to go with this. And there are many people who then just don't do the project.
Mr. Sidley?
Just on that point, often when you're applying for grants, state grants, federal grants, they want it to be shovel ready. And that's shovel ready as the EIR is done. And so, but there's also case law, which indicates that you can't basically, it's save terra is the case, and you can't predetermine the outcome. So you can't actually do the document and make this determination to get the grant. And so, because then you've predetermined the outcome, but you still want to apply for the money. So it becomes sort of an endless do loop that you're hearing that, you know, it calls for, I think, someone to look at that, because you have to get federal dollars. They all want shovel ready. You want to get your money and you want it working. But most times if you're doing an EIR, you plan up to about 40%. That's about as far as people will go. Otherwise, you're going to get a claim that you predetermine the outcome and then you start again. So it is difficult. And by this testimony, the complication is enormous. Just by the discussions we're having, I think you're getting a sense of how complicated this law is. So I don't mean to step on your testimony at all. I just, you know, I just know that has been a problem for many agencies trying to get money, and it's difficult to be shovel ready because you can't, or you do it and then somebody will challenge you because you've gone too far. So sorry. Thank you.
All right. If I might have a point of clarification, Ms. Oviatt, you're saying so that when there is an application for a grant, the granting agency is the entity that requests the CEQA. Is that correct?
That's correct.
Okay. That's what I needed to know. Thank you. Any other? I see no further raised hands. Let me thank you for.
Well, let me, Pedro, if I could just add to that, just to be, so the granting, there's twofold on that. You're making a discretionary decision to apply for the grant, and therefore the discretionary decision triggers CEQA, and or the person or the agency that is giving you the money wants the project to be shovel ready. And if it's shovel ready, then you are also required to do CEQA. So it actually, to be clear, it's both sides that to your specific question, that require the CEQA, because just to apply for the money in and of itself is not ministerial. By definition, it is a discretionary decision, which can require CEQA, and then you would go, and that's, I think what you're saying is you would do an exemption for that because there's going to be no environmental impact towards just applying for the money.
Yes, but I want to, now that you've said that, in my written testimony, I point out that state agencies have the same complexity. You know, they are supposed to defer to the first lead agency, which in most cases is the county or the city, and be a responsible agency. And what we have now is state agencies staff who then call up and say, well, we don't like what you did. We disagree with what you did. That is a function of new people, training, turnover, but it has certainly been shocking in the last few years, the number of times that we have gotten that call. Okay, the structure is clear. The lead agency does it. If you don't like and you don't want to be a responsible agency, then you have to step up and do it yourself, which is not what state agencies are doing. Many of the agencies just feel like they don't have the capacity, they don't have the expertise. And my answer is, okay, well, local government can't say that. I'm the last one. We like to say we're the last lead agency. There's nobody below me that I can defer to. So that is an ongoing, whatever, I firmly believe, whatever gridlock we have in the state of California is this morass of CEQA. I just want to talk about really quickly about the iceberg. I don't know what that comment was, but I will tell you, there are thousands of mitigated neg decks that never happened. And a large percentage of them either became EIRs or those people built in Texas, Wyoming. I can give you a list as long as your briefing books. And the number of companies I've met with who have not built in California because of CEQA. They didn't want to wait the 18 months. Their lawyers kept telling them it's uncertain. Why do they build in Kern? Because I told them, look, if you have courage, lawyers, and money, we can get through this if it's the right project. If it's the wrong project, you should take it out of state. California is not the place for every project. And if you're not willing to put it in the right place and mitigate, if you are, we can go through it, but there are hundreds of projects. And that's why you don't see as many litigated, not because they cut a deal with the neighbors, it's because they turned into environmental impact reports.
Very good. Thank you again for your testimony. And let me turn this over to Tristan if we have an additional witness.
Thank you so much for the opportunity.
Thank you.
Thank you, Chair Nava. Our final witness today is Tinnis Wick. Mr. Wick has served as Director of Permit Sonoma, Sonoma County's consolidated land use planning and development permitting agency since November 2013. Before joining the County of Sonoma, Mr. Wick worked as a principal at Berg Holdings, responsible for government affairs, site acquisition, design, and entitlement. Mr. Wick began his career with the County of Marin, where he served as development chief. Mr. Wick holds a JD degree from Golden Gate University School of Law and a BA degree in political science with a public service emphasis from UC Santa Barbara. He currently serves as president of the California County Planning Directors Association. Mr. Wick, you may please begin your testimony now.
Thank you very much. And thank you, Chair and Commission, for the invitation today. I know you have my written testimony. So first I'll begin by thanking for the order of witnesses. It's a pleasure to follow my old friend and colleague, Lorelei Oviatt. You can see why she's a leader in the state. Just a level of amazing practicality. As I mentioned in my written testimony, especially at the county level, we find ourselves stuck in a regulatory accordion. And I want to relate my personal experience in Sonoma County, explain how that relates to CEQA. Because I think they're, rather than trying to nullify this very important statute, I think if we can coordinate policy formation, we can avoid a number of these conflicts to begin with. So as many of you know, over the last 5 years, Sonoma County has undergone some rather significant disasters. And this has been a personal experience for me because, like many people in my position, we're not only directors of planning agencies, we're also the plan section chiefs in the Emergency Operations Center. So that is where I've spent over 62% of my practice in the last 5 years, dealing with significant complex fires in 2017, 2019, and 2020, and an enormous flood in 2018. So over that time, we saw the effects of and the need for a response to climate change. And because of that, we volunteered to be the first county to undergo the fire safe regulation process. However, as we went through that, because of the lack of coordination at the state level, in the formulation of policy, I could quickly see even the development of some single-family residences resulting in takings, and possibly even the need for an environmental impact report because of the way impacts were characterized in the draft regulations. So regrettably, I had to withdraw our application at the hearing when it was initially being considered for adoption. So as I said in my testimony, written testimony, that was really the first step of the accordion squeezing in by saying, don't build in the wildland urban interface. And the second example was with the regional housing needs allocation that happens on an 8-year cycle. So Sonoma, before it was an official designation, Sonoma County was really a pro-housing county. In the 5th cycle, we had met and exceeded through a sub-regional agreement our allocation for housing. And unfortunately, because of really disjointed formulation of the new housing policy for the 6th cycle, our reward was a 365% increase in housing allocation. The city of Santa Rosa, the largest city in our subregion, had a real decrease of 14% in its allocation. How does this relate to CEQA? Well, we were forced to, in the accordion metaphor, squeeze out again and put housing farther away from city-centered corridor, as our general plan dictates, not just in the county, but in our 9 partner cities. And then squeezing back in again with vehicle miles traveled. Probably the closest example of a recent statewide policy that impacts CEQA, where this traffic model was really designed to lessen the miles between primarily jobs and housing, and with a noble goal of reducing greenfield sprawl of endless subdivisions and sometimes speculative distribution centers. So laudable goal. Unfortunately, when you look to and combine it with the effects of RENA, it now requires housing elements to go through a full-blown EIR, when before, because we were concentrating housing closer to job centers, we could often do a mitigated negative declaration. So my recommendation would be that we really need to have better coordination at the state level when we're forming new policy. And as I made reference to, there's a settled model that the federal government uses in the Office of the White House, where there's a national policy council that, as policy is being formed, coordinates it. So in our case, think about fish and wildlife, housing and community development, Board of Forestry, those folks coming together either programmatically or ad hoc as the need arises, and deconflicting policy as it's formed. And then, as another White House office does, the Council on Environmental Quality, because things go through quite a change as they do in our very large and complex state, deconflicting draft policy conflicts before those policies become final.
Let me interrupt you, Mr. Wick.
Yes.
Commissioner Byer has his hand up.
Thank you.
Yes, thank you. I'm assuming what you're referring to is the Office of Information and Regulatory Affairs in the Office of Management and Budget within the White House. And let me just take a second for those who do not deal with the federal government all the time. It's a very powerful, unknown agency, but there's a threshold before they review a regulation. There has to be $100 million or more impact. And they've developed models going back, frankly, and rules going back to the Reagan administration about how to view the cost of regulation. And it's a very effective way, as we saw in the Clinton-Gore administration, and then since with other presidents, in regularizing the coordination function that you're talking. Very powerful idea that you're talking about, and there is a direct parallel, and we can evaluate the efficacy of, it's called OIRA, and how presidents, or in some cases in the state level, it would be governors, can slightly alter the regulatory coordination function to secure some kind of social policy goal. So thank you for the recommendation.
Appreciate it.
Yeah, Commissioner Arner.
So let me be sure I understand, Commissioner Byer, because what that sounds to me like is like, why wouldn't the Governor's Office of Planning Research, OPR, isn't that kind of what their job is supposed to be, is to look at when there's a common proposal out there, to look at how it affects all of the different agencies that the governor deals with? Why wouldn't that happen there?
Well, I'll let the witness answer first, and then I'll give you my views. Go ahead.
Good point. And OPR has a really great role. It changes in administrations, but it doesn't really, it really does have more of a traditional research focus. And I think this really needs to be something, as the Domestic Policy Council is in the White House, something that almost involves cabinet actors or their immediate undersecretaries. Same thing happens at the end with the Council on Environmental Quality. So I think it would be one where you need to be bringing in different elements of the super agencies, in California's example, to really either coordinate formation or deconflict draft policies, and include county and city officials in it, because we really are part of the team as subdivisions of the state. I mean, Lorelei and I will tell you, as she mentioned, we're that last stop in lead agencies, and we're the workhorses for policy implementation. So have us there and we can help.
Right. I think the other component is, as this witness and previous witnesses articulated, when the state makes a change, a fundamental change in terms of impact on rural life, vehicles, miles traveled, et cetera, it has a knock-on effect of the other structural underpinnings of environmental and economic policy. And the legislature is not well structured to make those assessments, and the executive branch really has to step that up. And so you could conceive of a requirement that any new environmental policy explain in the note that accompanies the legislation how it's going to interface with, conflict with, or overlap with CEQA. Because what's happening is every new law, whether it's moving from natural gas to electric trucks, has some effect on CEQA, and the legislature is dealing with it in a silo, and the executive branch ought to bring some order to that process. I think I captured your testimony, right? Yeah.
Yes, sir.
All right, Mr. Wick, go ahead. If you have more, we'd love to hear it.
Well, just a follow-on to the commissioner's comments. So we are working with members of the legislature, the Utilities and Energy Committee, very closely with Laura Scheibut, who's the chief consultant there, because of here's an example where we're trying to implement environmental policy and running into all kinds of problems. There is no one lead agency that is giving local government direction around renewable energy storage facilities. It is diffuse among at least 5 different state entities, from the state PUC to the Energy Commission. And we've testified before the Assembly Committee to say, look, we want to help. And it doesn't necessarily require significant modifications of CEQA, but just tell us how much capacity you need, where you need it, give us a little bit of money at the county level to do the CEQA in advance. So when these facilities come in, the CEQA is done, the policy work is done. We're essentially going through a checklist to make sure that everything's met. That's the kind of thing we really need. And right now, the system frankly is falling apart because you have private applicants who are coming in. They have proprietary needs. They're either not telling us the truth or they're telling us half-truths. They are opposing each other's projects through the CEQA process. And ultimately, none of us are served. So again, this kind of policy formation, coordination, and deconfliction, it would go a long way. Thanks.
Yeah, I do think that part of our conversation, depending on where and when you want to have it, is who benefits from the fact that there's this confusion. It benefits somebody. There is someone somewhere who appreciates the fact that there is the chaos. So it then you move the decision-making away from your day-to-day as a planner.
Yes.
And it bleeds into something entirely different.
Yeah.
And that, I think, is part of, if we can get our arms around some of that, depending on how hard you want to squeeze, we'll see. So go
I
ahead.
look forward to the recommendations that are going to come out here. I really hope the governor and the legislature pay attention to them.
Let me turn to my commissioners. Any other raised hands? Seeing none. Mr. Wick, I want to thank you for your testimony. I live in Santa Barbara, so we're kind of kindred souls. You haven't spent some time out there in Isla Vista.
You need to get back. Go Gauchos.
You're welcome anytime.
Bye-bye. Thank you, folks.
Thank you.
Thank you, Mr. Chairman. I believe that concludes our witnesses, but we now need to move to the public comment portion of the meeting. So if the staff.
Commissioner Hernandez.
My apologies.
Sorry, and just the new guy process question. I mean, these are amazing in terms of witnesses. In terms of process, is there a time that we as commissioners kind of talk out loud? I think that the chairman brought up a great point in terms of, I mean, there's a common theme here in terms of delay, uncertainty, who benefits, who doesn't benefit. We heard in terms of number of projects leaving the state. I mean, there's a process, is there an internal conversation that happens, or is it most of the witnesses, public testimony, our report, and then we react to the report?
Ethan, you wanted?
Sure. The normal process, the commission certainly can discuss these issues as long as we have properly noticed a meeting with an agenda item for commission discussion. Typically what happens, Commissioner Hernandez, is that the subcommittee considering this issue, the subcommittee leading this work, will meet with staff. Those subcommittees are not covered by the Bagley-Keene Act, and so we do not have to provide a 10-day notice with an agenda and so forth. The subcommittee meets with staff, considers potential recommendations, issues that might be included in the report, and then the staff presents a draft report to the subcommittee, and then following the subcommittee's work, the commission goes to the draft report goes to the full commission for consideration. Sometimes that results in approval, sometimes that results in additional meetings. So that's sort of the typical process, is to work through the subcommittee.
Yeah, Ethan, I see Vice Chair Varner and then Commissioner Sidley.
Yeah, Ethan, I'd like some clarification on what you just said, because when we have a hearing like this, I think it's important to hear from the commissioners and their perspectives on what was said by the witnesses testifying before the committee, before the commission, because I think some things were raised in there that sort of got my eye, as well as something that was not raised. So I would love to hear from Commissioner Hernandez and his comments, but let me know if there's some sort of something I'm missing with regard to the Bagley-Keene Act.
No, I don't think so. I think that if the agenda for this meeting is effects of the California Environmental Quality Act, so I think that would include discussion by the commission if the commission wishes to discuss it. That's really up to the will of the commission.
Commissioner Sidley.
So, as one of the co-chairs on this topic, which is so challenging, I welcome all of the input of the public as well as the commissioners. I need to hear your views. We need to know what you're thinking. This is going to be a challenging report to be written, a challenging report for people to read. So, I want to hear now in forms of questions. I think we're hearing your views also, please say. But for me as a co-chair, I can't welcome enough comment because first of all, that's what CEQA was about, but also this is what this report is. It's so challenging. So please, I want to hear it.
Commissioner Sidley, I know you're aware of this. I just for clarity for the full commission, that conversation should occur, that input should occur now in a public meeting. What I was trying to say earlier is we cannot have a series of emails that amount to a serial meeting. So I know you're aware of this, but that input should occur in a public meeting.
Understood.
Commissioner Hernandez?
Yeah, to that note, I mean, today someone talked about recommendations specific for the executive branch. And then I was thinking in terms of the ultimate report, I mean, sometimes the recommendations are aimed at the legislature, but it sounds like something so massive as this, there might be recommendations to different parts. I mean, there might be recommendations for the executive, for the legislative, for regulatory bodies, for local. So I think that's a conversation if the subcommittee, if the commission was looking at a varied kind of array of recommendations for different entities.
Let me look to Vice Chair Varner, and then Commissioner Byer.
Yeah, just a couple of comments that I had that some have been raised, and I just think they should be considered even further. Someone raised the VMI, vehicle mile, or VMT, vehicle miles traveled. I just like to make a comment from where I live in Riverside. VMT is a huge issue because the transportation infrastructure, housing, and jobs don't align. So when you try and use VMT as a measure of CEQA in implementing that, there's a regional aspect to it. Even in areas like Riverside, that it's not. I mean, there are urban areas of Riverside, so something to consider. The other couple of issues, one was raised today, was the document dump. There's things like this, I think, that are pretty obvious that need to be addressed, and I hope that that's something that gets into our report. And the third thing that I don't think I heard today, maybe I missed it, but what I find really egregious is that I don't know what unionized labor has to do with protecting the environment, and when that's used by labor to extract a project labor agreement, I don't think that's what this legislation was originally intended to cover. I actually wrote an article back in 1991 on CEQA, and a lot of the things that I wrote in that article are still being struggled with today. So I hope, Mr. Sidley, I understand the challenges with this, and with the testimony we've heard, it was really interesting to hear both sides, and that's what I love about this commission is we do hear all sides, and you know, it's helped me think differently a little bit about CEQA and some of the benefits of it that I haven't considered before. And so I know it's going to be challenging, and you know, I wish if without Bagley Keenly, I could be helpful in that, but we may just have to talk about it more when the report comes out.
Yeah, before I go to Commissioner Byer, and this is something we can discuss and get some consensus. We've got another hearing on May 11. I don't know how that's lined up. We have in the past, when we did this on other reports, scheduled a meeting whereby we had a different length of time for public comment. We opened up 2 hours, if I remember correctly, for public comment. I think what Commissioner Sidley, and I see Commissioner Aaron are nodding her head, Commissioner Varner, and Commissioner Hernandez. This report is going to be a little different from some of the things we've done before because of the nature of the issue that's before us, and because of its complexity, because as we learn more, we understand that there's a lack of coordination between agencies as they request things of applicants, for example, lead agencies and of counties. We are learning that there may be an element of this where you look to the judiciary, where there may be judges who have come to the conclusion that there are things that ought to be included in a CEQA review that had not been previously identified, which leads to what I think people have characterized as an element of surprise. And there's a number of things. So I don't think, and I think what Commissioner Hernandez has raised here is this looks to be a topic that instead of attempting to compress our discussion at a meeting where we adopt the report, okay, which is constricted, that we have a meeting where we talk about before we get to the draft, so that the subcommittee has input from commissioners and the public. So we coordinate that with a public participation to get as much information as we can. Now, let me turn to Commissioner Byer, followed by Commissioner Garcetti.
Mr. Chairman, I like your idea, assuming that the co-chairs of the subcommittee agree. I have two practical suggestions. Unfortunately, Tristan, this means you have to do more work. It would be extremely helpful to know the past legislative efforts on CEQA reform, and it can be from public domain information or otherwise. I'm reluctant to go down a fool's errand, and I'll use fee shifting as an example. I can play that one flat or I can play it round. I've been on both sides of that issue, both legislatively and as a litigator. But if that's not, is a non-starter with the legislature, no matter what the merits are, maybe we should focus on things that are enactable. So first is greater understanding of what's the art of the possible legislatively. And second, maybe more knowledge of how other jurisdictions, and I'm here thinking mostly of the federal government, but not exclusively, it could be other states, deal with these same kind of problems, because California as a nation state is competing with these other states for location of everything, from factories to housing to transit to infrastructure. And everyone is trying to do the right thing. But if we're disadvantaged because of the regulatory morass that we've created, that has a negative effect on the entire citizenry. And so I'd like to know, is it demonstrably different with federal projects on federal lands or in other states? So those are kind of two fact questions that I think could help us. Thank you.
Commissioner Sidley, and then, I'm sorry, Commissioner Garcetti, then Sidley.
Thank you. The issue for me is similar to what Mr. Sidley had said. This is an incredibly, the most complex issue that I've heard since being on the commission. And I don't want us to rush a report. I really want to be able to study this. I missed one meeting, but I listened, I viewed the tape of it. I think it's going to be necessary for me, I'm speaking only for myself, to really review all of this a second time, because to me, it's that complex. I think Commissioner Dreyer just pointed out something that I was going to ask about, and said, do other states have similar CEQA laws? How do they handle? What can we learn from that process? That can be addressed. But the other issue is, we've heard from all the people who represent the various sides except the judiciary. Have we ever invited anyone from the bench for any hearing? Can we do it in this case? Can we invite someone from the bench who's heard these cases before to come and offer testimony?
Mr. Chairman, if you'd like, I can answer that question. The answer is that we can, and Tristan and I have discussed witnesses for the next hearing, and some of the discussion, we're still in the process of inviting people, but some of the discussion has focused on issues connected to potential reforms that touch upon the judiciary. I'll just leave it at that. So we're still in the process of inviting witnesses for the next hearing, but we are considering those issues.
Okay, well, leaving it with that vague response, I would strongly urge you, if we can get a representative from the bench to testify, it would be extremely helpful. That now we have all the parties who are directly affected by this. I did this, when I was district attorney, and this was a long, long time ago. Domestic violence cases, judges hated domestic violence cases. Everyone hated domestic violence cases because the witnesses would usually, the victim would usually come in and we kissed, we made up, didn't make any difference. There was a gun pointed to her head the night before and it forced her to say this. And the judges were reluctant to handle these cases in a timely way and in a proper way. We finally, pushing through, the judges who handle these cases had to have special training on domestic violence, what it's all about and how they have to be handled. Maybe that's what should be done here if it's not done here, because I'm not sure if every bench member in Kern County or wherever it is, oh no, don't give me one of those cases. And someone handles it. So if we could find out a little more about all this, I think it'd be very helpful for all of us.
Thank you. Mr. Sidley, followed by Commissioner Hernandez.
So a few things, Commissioner Garcetti, there are other laws, NEPA, the National Environmental Policy Act, similar. I would say that California's structure and use is the most broad, but there are others. That having been said, I think seeing that information is obviously helpful, not just from me but an actual learned paper on that. And then I also would say to you that there are classes for judges that look at CEQA cases. There are specific CEQA judges in some of the areas, not all. And there's quite a bit of forum shopping around that because,
Sure.
We know what those judges and how they decide, et cetera, et cetera. So I just leave that at that. And I just, for Commissioner Byer, just so you know, as somebody who's on the co-chair, I am willing to put in a suggestion that may have been suggested in the past and doesn't go forward. I think that that's what my role is. If I've listened to all of this and I have a suggestion that I think is better for the citizens of the state of California, just so you know, I'm willing to put it there. Okay. Right. And so I just had to say that it may go nowhere, but I'm willing to do it because that's what I feel my job is of listening to all of this, is to make what I think are the best recommendations. So I love you, Commissioner Byer, to my heart, but I just needed to say that.
having been schooled by Commissioner Emerson and Commissioner Aaroner on developmental disability, their judgment on that one was much better than mine.
Yeah. But I also think we need to realize that the legislature has also changed, right? And so what maybe didn't get through the legislature 5 years ago, 10 years ago, whatever, that was my experience. I had advocates who waited me out. In other words, they had legislation they wanted to get passed and I stopped it. And I can assure you they got it passed after I left. So things change, right? Not at all of the ends in doing this. And so I think it's important that we make the best decisions that we can and recommendations and take our chances as to whether or not someone's going to take us up on it or not. So.
Commissioner Hernandez.
Thank you. I just wanted to kind of reiterate what Commissioner Garcetti talked about in terms of judicial. I think it was brought up at the last hearing, the whole kind of a CEQA court. There were kind of concerns in terms of if it turns more to rulemaking like the CPUC, then I would say no way, Jose, in terms of kind of that process. But if we can really take the expertise, I think that we heard from Kern in terms of, they have expertise, they have history, kind of that knowledge. So if we can kind of extrapolate that and figure out how to do something better on judicial, I would also like to hear more from folks on that end.
Thank you. Commissioner Aaron, you're unmuted. Did you want to speak or did you? Okay, that's fine. That's fine. You're okay. All right, we still have 30 minutes of public comment remaining. I'm guessing the direction to staff was that we're going to need a meeting where the commissioners have an opportunity to engage in a further discussion with various areas. Apologize to staff, it's more work. And that meeting would include opportunity for members of the public to be heard as well. Having done that, let's take a look at public comment.
All right, thank you, Mr. Chairman. Then we will, understanding that direction to staff, we will work on that after this meeting. So we'll turn now to the public comment portion of the agenda. Members of the public who have joined the meeting via Zoom and who wish to make public comment should use the raised hand function. If you have phoned into the meeting, please email us immediately at littlehoover@lhc.ca.gov. That address is on the screen, littlehoover@lhc.ca.gov. In keeping with the Commission's longstanding practice, public comment is limited to 3 minutes per speaker. And if you make public comment, the commissioners will be able to hear you but not see you while you are speaking. So again, 3 minutes. Please limit your comments strictly to 3 minutes so that we have the maximum opportunity for more people to make public comment. Again, if you've joined by Zoom, just raise your hand. That's by far the best way to do this. We will take public comment in the order in which people requested it. We've limited the public comment period to 30 minutes total for this meeting. So if you are not selected to make public comment, as you've just heard, we will be having additional hearings on this topic. You can make public comment at a later date, or you can always email us your public comment and we will incorporate that into the Commission's research. With that, I will ask Shara if we have people who have indicated they wish to make public comment.
Thanks, Ethan. We do have some people in line for public comments. Our first comment is going to come from Marianne King. Marianne, you now have the ability to unmute yourself.
Hi, can you hear me?
We can.
Yes, we can.
Thank you. Good afternoon, commissioners. Great discussion. My name is Marianne King. I am a former city planner for the city of Los Angeles, about 20 years and 2 years retired. I want to share with you that I believe CEQA is an invaluable tool as a planner to review projects. It is the checks and balances that are needed to ensure there is no harm to the environment, including wildlife and human health. It's an invaluable tool because you also have public input. There are people who know their neighborhoods well, and they can share information that is helpful to also make sure a project does no harm. When we get all this input and the environmental document is done well, meaning it's not boilerplate, it is specific to the project, to the site, it usually is a win-win. These are feel-good cases, and the majority of them are. My concern is the permit streamlining, the direction that seems to be the pressure from the state, from the city. Everyone's pushing for housing. I understand it, but not at the expense of the environment. So those are my concerns. I will tell you that as I have been retired, I do research, and I'm looking at specific inefficiencies that are done. CEQA to me is not the problem. There are some groups that abuse it, yes, but overall not the problem. The problem to me is inefficiencies in the departments that process CEQA documents and planning cases. So maybe they're not well staffed. Another one is applicant delays. Applicants will submit a case and then we'll be waiting for additional documents. So the case is put on hold, but the clock is ticking. So those are the realities that I see that a lot of people may not realize. And I just believe CEQA now is more important than ever due to climate change. I am a tree preservation advocate. And I have to say, as I watch cases, if they are, a lot of them are CE32s and field developments, we're still clear cutting trees here in Los Angeles, and that needs more attention. And without CEQA review, I believe we're going to have cumulative impacts and unusual circumstances that will go unabated. For years and years and years. So I'm concerned with the direction, and I think I will write you a letter as well, because I have a lot on my mind. But I really appreciate the discussion. And one more thing.
Ms. King, your 3 minutes has expired. Can you please wrap up very quickly, please?
Thank you very much. Bye.
Thank you. Sheriff, we can go on to the next speaker, please.
Thank
Clara
you.
Solis. I am from East Los Angeles. I support CEQA. Environmental justice communities need it desperately. In fact, if there is one thing I would change, it would be to make it stronger and allow less categorical exemptions in environmental justice communities. Alternatively, funding should be provided to EJ communities, as I did in 535, to hire attorneys when categorical exemptions are requested for larger projects. If you ever attend a meeting in East LA, ask who has asthma. Most will raise their hands. East LA is impacted by redlining and racist practices of the past before CEQA was enacted. East LA has 4 major freeways intersecting and containing the community. Pollution, both air and noise, impact almost every block. East LA is not the only community facing this. Environmental justice communities along freeways throughout the state are impacted. Additionally, overbuilding and providing access to and from freeways means that these areas face heat island impacts. As a child, I watched as our native parkway trees on my street were all removed to allow easy access for the I-710 commuters to exit on my street. We need our native trees to protect our communities. EJ communities will be impacted by climate change most. Historical racism, poverty, redlining of residents of environmental justice communities means they are more likely to use and have rail and public transit. These communities are already some of the densest in LA County. Recent changes in California, removing parking in areas with public transit are allowing more market rate density and taller buildings in EJ communities. Communities like Beverly Hills don't have transit and will continue to have less density. They claim that removing parking will not have impacts, but because communities near freeways have pass-through traffic and the new housing residents have cars, these communities are facing more cars circling, causing more traffic and pollution. If there is an accident, traffic backs up for hours. Residents abandon their cars and walk home. This impacts emergency services. Residents have died waiting for service. We need CEQA to look at all the environmental impacts. Concentrating more density in already dense communities also causes cumulative impacts. EJ communities need CEQA to protect them from cumulative impacts from past, present, and probable future projects. EJ communities need CEQA because politicians ignore these communities. Because of historical racism, voter turnout in EJ communities is low. Campaigns concentrate their efforts on communities that vote, perpetuating low turnout. Sometimes these communities' only recourse is CEQA. VMT is important in LA County. Thank you.
Thank you, Clara. Our next person is Tom Williams. Tom, you now have the ability to unmute yourself. Actually, Tom, stand by.
I'm seeing Joanne.
Sure. Yeah, I believe we promoted Joanne D'Antonio. We can go to her if that's
Okay. We'll go ahead and do Joanne. Just one moment.
Joanne D'Antonio.
Go ahead, ma'am.
Okay, thank you. Joanne D'Antonio, Los Angeles Neighborhood Council Trees Committee Chair for the Neighborhood Council Sustainability Alliance. I am speaking as an individual today. I truly appreciate this discussion today. I want to question the state's setting of RHNA numbers without bringing up their effect on the environment. It puts pressure on our elected officials to abandon.
You're muted, Joanne.
Sorry, I thought I had unmuted myself. Okay, I'm Joanne D'Antonio. I'm the Los Angeles Neighborhood Council Sustainability Alliance Trees Committee Chair, and I'm speaking today as an individual. I truly appreciate this discussion today. I want to question the state's setting of RHNA numbers without bringing up their effect on the environment. It puts pressure on our elected officials to abandon environmental quality and not look at a city's environmental care capacity. It may not be sustainable to build the amount of housing the state requires. There are tens of thousands of market rate unoccupied units in Los Angeles, yet we are asked to allow building at any environmental cost. Developers in at least my city, Los Angeles, do not approach their projects from a standpoint of what can I do to preserve as much of the natural environment as possible. A developer will take out an oak walnut woodland, calling it infill or deeming it irrelevant to the overall tree canopy reduction or wildlife habitat loss they are causing. They look at CEQA as something they have to get around, not from the standpoint of every tree we can preserve as an asset to the city. If equity trumps environmental concerns like trees and wildlife, which have important health assets, we are saying that lower income people don't deserve health. Our city and developers have become bullet dodgers instead of looking at what can we do to preserve environmental assets. I like the idea of the CEQA first proposed by Mr. Wick. Can CEQA address certain environmental concerns like trees and habitat even before the design is put to paper? 30 by 30 will not happen unless we have incentives for developers and cities to preserve trees and woodlands. As chair of the NCSA Trees Committee, when big trees come down, the stakeholder complaints find their way to me. Stakeholders who pay taxes want an environmentally responsible city to live in. We should not be adversarial. We have become that because we see the environment destroyed by developers, and the cities don't want to work to preserve trees and habitat. We have a lot of CEQA exemptions here in LA, and residents complain that they can't save small numbers of trees, yet these removals add up and the canopy is declining. Finally, comments have to be taken seriously and plans changed. For example, ideally, we should not be taking out 100 trees to revamp a park for amenities like more parking, but LA is planning to do that at Silver Lake Park. If the many stakeholder objection comments to CEQA review are not adequately addressed with a better plan that does not remove the 100 trees at this park, the FEIR will end up in court. And
Ma'am, your 3 minutes has expired. If you can wrap up quickly, please.
Yes, and the neighbors are rightfully prepared to do this. Thank you for having these hearings, and I look forward to some balanced reform.
Thank you.
Thank you, Joanne. Our next speaker is going to be Tom Williams. Tom, you now have the ability to unmute yourself. If you're on the phone, you'll need to hit *6.
Hello, Dr. Tom Williams, Los Angeles. And might say I did my first EIR in 1972, so I'm somewhat elderly, but still the Brown Act and CEQA changed the life. And it got it out of the back room and got it into the public realm. Public participation is paramount. Without it, it doesn't work. Now, for your particular issue, try the Department of Finance, which gives regional government associations the number of people, households, and jobs by traffic, transportation, assessment, or analysis zones. And those have to be complied with by the cities. So you first have to get the state under your jurisdiction through the Department of Finance and the regional allocations of population, jobs, and households. Therefore, I say get the state organized under CEQA first, and then apply it to the regional governments, such as Southern California Association of Government, because we're fighting this continually. Even after 50 years, we still have problems that we have to comply with both the public and we have to provide compliance with the State Department of Finance. So it's a very important element there. We are trying to work with the Office of Planning and Research, and that's doing a great job, but it doesn't have jurisdiction over the Department of Finance, which feeds the population growth, the jobs, the commuters, and we have experienced this in several of the community impact statements within the City of Los Angeles general plan, which has to be complied with. And every, 9 years or so, 8 years? And it's difficult to deal with that because we don't know who's coming up with the population projections, the households, number of units, and especially the jobs, which required in one case, 2,000 people had to commute every day into a very small zone area because that's what the state said the community plan had to deal with. So get the State Department of Finance and its associated projections of population, households, and jobs under control so that we can comply with it and require the Department of Finance to provide a environmental assessment.
Thank you, Mr. Williams. Your 3 minutes has expired. Please wrap up quickly.
Done.
Thank you, Mr. Williams. Cheryl, we can go on to the next speaker.
Thank you, Tom. Our next speaker is going to be Mercedes Macias. Mercedes, you now have the ability to unmute yourself.
Hi, thank you. My name is Mercedes Macias. I am an organizer with the Sierra Club in Kern County. I'm a lifelong resident of Kern County as well. I want to give my support and perspective on CEQA as it has been vital to the protection of public health and the environment, especially in places like Kern County, where decision makers have little regard for the concerns of frontline communities who deal with the impact of those decisions. A community in which by design is kept as one of the most polluted counties in the country. It is by design incredibly difficult for frontline communities to vote for decision makers who are aligned with public health and safety. That is to say, we are a community historically disempowered. If we as grassroots community groups had good faith that decision makers and private industries have the best interests of the community in mind, CEQA would have never been created. As it were, CEQA is the only thing standing in between our community and those private interest groups. In Kern County, there are projects that want to go forward on a singular EIR in situations that require individual project review and pushed as a way to expedite or even as a means of efficiency, but it ends up being neither efficient nor effective, and in many cases, extremely costly. The process by which the law is serving the community may be difficult to navigate, but as our lawyers have pointed out numerous times, county decision makers can choose to do as they will, knowing the consequences of going against CEQA procedure, thusly contributing to the costly lawsuits. Lastly, I want to say that justice is not often seen at the end of these planning hearings or at county hearings. Environmental justice must be at the forefront of projects that have the biggest environmental impacts. So it is my recommendation that as part of this process and recommendation is that environmental justice review be at the beginning of all projects. Thank you.
Thank you. Our next speaker is going to be Mike Feinstein. Mike, you have the ability to unmute yourself.
Hey. Hi, everyone. Mike Feinstein, former Santa Monica mayor and city council member, a big affordable housing advocate when I was on the council. It's important, obviously, that you've been considering the economics of unreasonable CEQA delay and how that increases the cost of building affordable housing. And while that's important to consider, it's also important to consider the cost of land, which is often seen as sacrosanct. I'm a big advocate of land value taxes. That gets at the problem in our current system where we privatize the socially created value of land to property owners that comes from infrastructure improvements, population growth, location, legislation. This raises the cost of land by disproportionately promoting land speculation while at the same time putting less money into public coffers, which then makes it more expensive for public goals like housing, parks, hospitals, education facilities, and has led to the fiscalization of land use in land use planning, promoting big box auto-dependent commercial development that brings in sales tax revenue over the housing that we need, which increases costs for schools, public safety, parks, hospitals, educational facilities. With the land value tax, more of the publicly created land value is captured, that provides more funds for the public to support affordable housing, and such funds would be a help for cities asked to comply with affordable housing mandates in the RENA process, but have no funding for it, and thus must accept market-based housing projects that contain a small number of affordable units as the only way to achieve mandated and desirable affordability goals. And this often brings pushback from local residents, including use of the CEQA project. So what I'm hoping your commission does in its recommendations is acknowledges how it is important that there be complementary reforms and not try to use CEQA reform to solve the whole problems of economics of housing production. Thank you.
Thank you. Our next speaker is going to be Laura Thomas. Laura, you now have the ability to unmute yourself.
Thank you. Thank you very much. Let me get my notes here. I've been patiently waiting. My name is Laura Thomas. I've lived in Orange County for 54 years and have been a real estate agent for 3 decades. As a volunteer in my community, I can testify that CEQA has made a big difference in our county. I hold the California Environmental Quality Act in high regard as it has protected our precious natural resources, given the average citizen a voice, and helped to inform decision makers and the public of adverse impacts to a project. Filing a CEQA lawsuit is actually the last thing citizens group would want to do. It's difficult and costly. And while CEQA has never been our first choice, it sometimes has been the only remedy and path available to get developers to abide by California environmental law. A case in point was the CEQA lawsuit citizens filed to protect Barham Ranch, a 500-acre parcel surrounded by 3 regional parks rich in biodiversity and sensitive habitat. Barham Ranch was a critical linkage to these parks. The loss of Barham Ranch's unique wildlife and biological resources, including wetlands, riparian forest, and numerous threatened and endangered species, would have been devastating. Our group worked in the public interest to protect these natural resources. It was such an important CEQA case that the state attorney general filed an amicus brief in support of our coalition's effort to save this pristine area from development. No other law would have allowed for accountability in this way. As a result, Barham Ranch is permanently preserved and part of Santiago Oaks Regional Park. Our county would look very different without CEQA today. Barham Ranch would have been paved over. CEQA has been amended in recent years to streamline or exempt environmental review for worthy projects. As a real estate agent, I know CEQA is not a major hindrance to housing. Thankfully, CEQA has been updated to address serious crises like wildfires in dangerous wildfire zones. Barham Ranch is in a high fire zone. 90% of it burned in 2007 and again in 2017. Leaving this area as open space turned out to be a responsible and wise decision. The California Environmental Quality Act has been serving the public good for over 50 years. Without CEQA, Barham Ranch could have become a disaster zone for residents, but instead became a beloved regional park with quality of life for all users. Thank you very much.
Thank you. Our next speaker is going to be the Los Angeles Conservancy. You now have the ability to unmute yourself.
Good afternoon, commissioners. Adrian Scott Fine. I'm with the Los Angeles Conservancy. I also currently serve as the president of the board of trustees for the California Preservation Foundation. We routinely work within CEQA confines where historic, cultural, environmental resources may be facing significant adverse impacts, similar to federal NEPA and Preservation Section 106 processes. When CEQA works well, it is a critical process in helping to bring parties together to seriously consider alternatives, mitigation measures, and work to reduce the environmental impacts. And that's where lead agencies work to facilitate these processes and engagement. CEQA, however, more often can generate equal frustration on all sides when a lead agency simply goes through the motions, checking off boxes, and dismissing viable alternatives and simply adopting statements of overriding considerations when not merited or following CEQA procedures. CEQA is a complex, I think we all agree with this, but we also think it's a critical tool and safety net that empowers communities to press for environmentally superior alternatives and find win-wins. It's compromises like these that make for better outcomes. We really appreciate what you all are doing, the conversation you're having, and looking at pragmatic ways to ensure CEQA is still here for us as a vital tool for looking at environmental impacts, but also ensuring that it works to the best degree as possible. So thank you.
Thank you. Our next speaker is going to be Thomas. Thomas, you now have the ability to unmute yourself.
Thomas, you are still muted. If you can unmute yourself, please.
Hello, can
Yes, we can.
Oh, great. Thank you. There was a sort of extra process. So my name is Thomas Ells, and I'm a civil and environmental engineer, and I'm a third-generation civil engineer from Southern California, though I live in Northern California now. Thank you for your efforts and direction as I've been listening. I was involved in, my family was involved in many, many projects. I myself was the lead engineer in Menifee Lakes, and I was a subordinate engineer in Rancho Santa Margarita and some of those developments in that area, just to give you an idea of some of the scope of the developments. And I was also at a the largest national architectural firm. Before that, before Menifee Lakes and so on, I was at the largest national architectural engineering firm. We did malls, and none of the developers wanted to use CEQA. So there's a lot of avoidance of CEQA. I can tell you directly, none of them wanted to use CEQA, and for the community, it's very important. It's vital, as we know. So what you're doing is very important. I appreciated Lorelei Oviatt's statements and the LA planner pointing to the agency and staff deficiencies. That's really where you have a lot of problems. It may not be deficiencies. They may have some knowledge, or they obviously have knowledge, but my point is they're not willing to make decisions sometimes because that can anger local developers, which then puts pressure on the politicians who then, cut back on the budget for the planning agency or whatever it is. So I also agree with the coordination comments from Kenneth Wick. I sent in written comments to you, and they're very particular. I hope you have the time to look at those with respect to the CEQA and EIR documentation. I appreciated especially Mike Feinstein's housing finance needs complementary reforms to CEQA, because that does present all those problems that he mentioned. And I also appreciated the tree planting needs. Those are urban forests are incredibly important in terms of the local environment and as well as the broader environment. So trees are very important. Rooftop gardening, all these things that we really need to do, and we don't get a chance to think about them under the current milieu of development consideration, much of which is forcing the largest developers, and we end up with too big to fail, and then they fail. So it's very, very complicated. It's directly with regard to the banking and financing. We have to really consider these to make it more available for smaller developers, but not then give an open door to the largest developers, the ones with the greatest money, the greatest resources to bulldoze everything. So thank you very much.
Thank you.
Thank you. Our next speaker is going to be Sofia Quiñones. You now have the ability to unmute yourself.
Can you hear me?
We can.
Yes, we can.
Permiso de mi la palabra. My name is Sofia, representing the East LA Boyle Heights Coalition, and I want to echo the comments that Gladys Solis testified to. We're in a crisis in Los Angeles, and unfortunately, the powers that be have left us behind. That's the systemic racism that goes back to colonial times. I live in a community where we have died, where we're dying, where we're chronically sick. Our families and our environment will forever be impacted. And we have to preserve CEQA. And unfortunately, the governor and our elected officials are not listening. They're doubling down on segregation. How can you build more housing in an area that is already a toxic green zone with multiple forms of contamination? The comorbidities of our illnesses combined with the continued pollution is going to shorten our lifespan. We know that. And when we have developers and multinational corporations pushing affordable housing is not low-income housing. And I want to talk about Angela Merkel, who watched and said, I'm going to do a moratorium on housing because we have multiple national corporations. The Panama Papers, the Pandora Papers have shown us that we have people who are on terrorist watch lists, countries that are sanctioned, can legally launder money by purchasing property because we do not have a way to verify who the owner actually is of the properties. We are being taken advantage of. This is a national security. There is no registry for the official owners of some of these LLCs. So when you tell us to build and build and build, we cannot sustain it. There is no water. We're violating several lawsuits. And when we talk about the public trust, well, we don't trust our politicians. Even the Attorney General, the lawsuits that he's put forward, yes, they've been won, but I see them as prima facie lawsuits that did not include what the community wanted in those lawsuits. And I want to bring up Exide and Quemetco, two battery facilities that have contaminated us. And when I reached out to the doctors who worked on the implosion of 9/11 and the Arab Brockovich case, they talked to us and told us that the current science that is being used to detect those of us that are sick and have been exposed to decades and decades of this toxic chemicals that are in our bodies, the tests that they currently use do not detect long-term lead exposure. So when you have our legal elected officials or our representatives suing, but not having the science to prove that we're sick and we're contaminated because they don't even have the medical machines to scan our bodies, there's a problem. And so for anyone who wants to bypass CEQA, it's because they haven't lived in our shoes and haven't felt the pain of losing so many. So when I speak today, I speak on behalf of all those who have died, all our ancestors that are dead, all our children that are sick, our children and adults that have had to live in Pampers and will live in Pampers for the rest of their lives because their brain have been affected by these neurotoxins that have just destroyed our genocide. This genocide. And so therefore, I call upon you that are listening to pay attention to us, to not exclude us, that we have to have a seat at the table, negative declarations, even with culture of corruption. Let me just finish, that the MTA and the LA County Med done, that agency has to be investigated. They're a part of the problem and the culture of corruption that exists in the city of Los Angeles.
Ms. Quinones, please wrap up quickly so that others can make public comment too. Your time has expired.
And I just want to say that in the future, that this board have a form of having public comment that is not violent, when people who are sick are not cut off. That is a form of violence. So I ask that you have a special hearing for people who are sick, to have a trauma-based approach at testimony for those that are sick. And it was the 9/11 families who taught us that. We will not be cut off at 3 minutes. You will have to have a special meeting for those who are sick.
Thank you, ma'am. Thank you, Ms. Quinones. We'll go to the next speaker, please, Cheryl. Well, commissioners, we've just about hit our 30-minute public comment period. We'll have one more speaker.
Thank you. The next speaker will be Michael Wellborn. You now have the ability to unmute yourself.
Good afternoon, commissioners, members of the public. This is Michael Wellborn. Can you hear me?
We can.
Great. So I spent 26 years working in the County of Orange doing land use planning in a variety of opportunities. The important situation as president of Friends at Harvest Beaches and Parks here in Orange County is that CEQA provides a backstop for those that don't have a voice. It's very important to understand that communities who are underfunded, disregarded, and left out of the process needs an opportunity to get their voice heard. So I would encourage your commission to really emphasize the opportunity for public comment, public input over a long range of times, not a 30-day or a 45-day period, but to really emphasize public input for various projects that will affect these communities for years to come. And I appreciate your time. Thank you so much. And I hope for a solution. Thank you so much.
Thank you, Mr. Chairman. So we have reached the 30-minute limit on our public comment period for this meeting. For members of the public who wish to make public comment, I know there are some who were not called on. Again, we will have, as you heard earlier during the commission discussion, we will have future meetings with additional public comment periods. You may also email us whatever comment you wish at littlehoover@lhc.ca.gov. Mr. Chairman, that concludes the agenda. The next meeting is May 11th, and we will obviously be planning that meeting in accord with the new guidance from the commission. But
got it.
Turn it back to you, Mr. Chairman.
Yeah, thank you. And before I let everybody go, I'd be remiss if I didn't point out one of the goals that we have as the commission is to influence the legislature to have authors submit bills that support our recommendations. Well, you should know that when we are successful in doing that, it doesn't come without some kind of a cost. And Ethan would never tell you this, so I'm going to. There was a bill, yeah, you're shaking your head. There was a bill that was up that embraced a recommendation that we supported. And so Little Hoover Commission was asked to appear in support. Well, that bill was not called until 10:45 p.m. after Ethan had been sitting in the audience since around 5 o'clock. So above and beyond, I guess that's why you get the big bucks. But I think everybody should know that our executive director sat in a hearing room in the legislature in order to offer testimony in support of a bill, and he was there until 10:45 at night. So
thank you, Mr. Chairman, but that topic is not on the agenda, so we may not discuss it.
I guess, all right, so I've just violated some kind of law. Anyway.
Thank you, Ethan. Appreciate your help, but I did think that the chairman was the one that got the big bucks.
Oh, you're right, and I'm spending it all tonight. Hey, thank you, everybody, for a vigorous discussion, and as you heard, we're going to ensure that commissioners and the public have additional opportunity to weigh in and offer comments and their perspectives on the CEQA issue. Thank you, and we'll see you soon. Bye, everybody.